Will he be participating in the decision?
All rise, please. Hear ye, hear ye, hear ye. Supreme Court of the State of Idaho is now in session.
Thank you. At this time, we're on record in case entitled White versus Valley County matters before the court for oral argument. In this matter, the attorney for the appellant, Victor Villegas, will be arguing. Joseph Borton will appear. Attorney for respondent, Chris Meyer, and will argue, and Martin Hendrickson will appear. Justice Eisman is absent. He'll listen to the recording, participate fully. Any preliminary matters? Very good. You may proceed.
Good morning, Chief Justice Burdick, Justices. May it please the court and counsel. The matter in front of you today is a certified question from Judge Lodge, and it's a limited question. And I'd just like to read what that certified question was, which is, under Idaho law, when does the statute of limitations begin to run on a cause of action arising out of an allegedly illegal impact fee imposed by a local government entity as part of a land use application? Now, the appellants have submitted that the statute of limitations should accrue at the time the fee is collected. And in support of that argument, we've cited cases from other states, both dealing with illegal impact fees or illegal taxes, to illustrate that the cause should, in fact, accrue at the time the fee is paid. In all of these cases, the fee payer was seeking a refund, similar to what the appellant, Karen White, is doing in this matter. And Ms. White is seeking a refund for the road development fees that she had paid for phase one of her subdivision. And in all of these cases, Your Honors, what is common to all of these, as we've pointed out in our briefing, is this issue of ripeness. We believe that until the money is actually collected, a case for a refund is not ripe for review. And therefore, that's what we've asked this court to adopt. Judge Lodge called it the majority view. There are two cases that have held otherwise, that the statute of limitations should accrue at a time previous to the collection of the fees. However, as we've discussed in our briefing, that should not be the law adopted here in Idaho. In particular, the two cases in which Judge Lodge cited to were Ponderosa Homes and versus City of San Ramon, and Frederick versus North Palm Beach County. We've submitted that Ponderosa Homes versus City of San Ramon is distinguishable from the cases and should not be adopted here in Idaho, particularly when you look at the facts and the reasoning of the California court in that case. In that case, they weren't talking about statute of limitations. The court was actually looking at a state statute, specifically California statute section 660-20. And in that statute, there was language in there that said the fee payer had 180 days to challenge a fee when it was imposed. And that's why the court went that way and didn't go with when the fee was collected.
Well, I take it that Ms. White realized when she got the conditional use permit that she was going to have to pay something.
That's incorrect, Your Honor. Actually, that's actually a question that's still to be debated in front of Judge Lodge.
Didn't it say that she was going to have to enter into a development agreement?
Correct, but there was...
Didn't the county have a program that said you're going to have to pay for the roads if you want them paid up front?
No, the record before this court, Your Honor, is the capital improvements program had not even been created yet for that, and therefore there was no answer whether or not a fee would be created. In fact, if based on whatever the Valley County's engineer would have calculated, the fee could have been zero. We don't know.
Didn't the CIP calculation as to how much was going to be required per lot come into effect before the 4-year statute that everybody has been talking about started to run?
I don't recall, Your Honor. What I do recall from the record is that the amount, and Judge Lodge found this on our cross motions for summary judgment, that Ms. White's representative, Scott Finley, they did not know what that calculation would be until the actual road development agreement was placed in front of them days prior to approval of final plat for Phase 1.
But I take it that when the conditional use permit was issued, there was no request within 20 days for judicial review?
There was not.
And why is that?
There was nothing to ask for at that point. We didn't even know what the answer was.
There was no indication whatsoever as to what this road development or what this road development agreement would be?
No.
Nobody even knew what road development agreement meant.
Well, I can't speak as for my client. That's obviously something that's going to be developed at trial, Your Honor. But as far as our position is, no one knew what, if any, condition would be imposed in terms of paying a monetary fee.
Okay.
May I proceed, Your Honor?
Sure.
Thank you. So the other case that's on the minority view was Frederick versus North Palm Beach, and that was a Florida case. And in that case, we submit, Your Honors, that this should not be the law adopted here in Idaho, where in the Frederick case, the court held that the statute of limitations for a cause of action seeking a refund of fees should accrue at the time local government either approved or created the assessment. Now, we believe that's the wrong law here in Idaho, particularly given the multitude of cases from this court that have held that the power to tax is not self-executing. If we look at this Frederick decision, and as we've discussed in our brief, I believe it would be bad law to adopt this holding that basically would allow a unit of government to implement what would be an illegal tax, wait the 4-year statute of limitations, and then apply it. And it would insulate them. So therefore, we submit that the Frederick holding as well should not be adopted.
It looks to me like the U.S. District Court judge talked about illegal impact fees well, that was in the certified question, but he led up to that by talking about illegal tax. Are they one and the same?
Your Honor, in our opinion, it is. The Idaho Development Impact Fee Act basically is a statutory measure that allows a unit of government to collect what otherwise would have been a tax. And our position was by not following the Idaho Development Impact Fee Act, they've they've collected a tax without any authority whatsoever. Therefore, it would be an illegal tax. Your Honors, at this point, we'd like to submit again, just as we stated on the brief, that we ask this court to adopt the majority view, and that is, with respect to answering this certified question, that when there is an illegal impact fee imposed by a local government, the statute of limitations should accrue at the time the fee is collected. With that, I stand in for any questions.
None. Thank you, sir. Thank you. On behalf of the respondent, Ms. Myers.
May it please the court, my name is Chris Meyer of the firm Givens Pursley, representing Valley County. With me at council table is Martin Hendrickson. If the court will indulge me, I would like to also acknowledge that in the courtroom with me today is my dear wife of 26 years. I really hope I got that right, honey.
Suffering that might.
Yes, as has been pointed out, after all these many years, she's finally decided to attend one of my oral arguments. This is her first.
I hope she understands your arguments.
I think, yes.
It well could be the last.
Yeah, I fear that. We are here on a certified question. And in my view, Your Honor, the process of certifying a question of state law to the state court is really one of the nobler aspects of our judicial system. It provides for an opportunity for integration in what would otherwise be a cumbersome and potentially inconsistent system of state and federal courts, but it certainly requires a combination of deference and candor and restraint in order to accomplish that. To be effective, the court needs to answer the question fully, but no more than that. And this court in St. Luke's versus Luciani cautioned against answering extraneous matters. Valley County honors that admonition. On the other hand, it's important for the court to fully answer the question and not to be bound by the structure or framework suggested by the requesting court, and in particular, not to remain silent as to a false premise implicit in the instructions offered by the asking court. If you will indulge me, again, I'd like to offer a silly example to address a serious question. If someone were to pose the loaded question, when did you stop beating your wife? The proverbial question. In order to provide a full and honest answer to that question, the responding party would be entitled to point out the false premise and to explain that he is not a wife beater. Now, doing that is not answering an extraneous question. Now, this is not a perfect analogy to what is going on here, because the false premise is not contained in the question that was certified. I certainly hope that there's no false premise in that question, because I wrote that question. I know the court has read it 100 times, and we just heard opposing counsel read it, but the key phrase out of that question is, when does the statute of limitations begin to run on a cause of action arising out of, let me emphasize, an allegedly illegal impact fee? Now, an allegedly illegal impact fee is a very broad description. That would include any reason that it was allegedly illegal. That could be because it violated the takings clause or it violated the taxation clause. In short, it isn't limited to a particular cause of action. But although the court certified this very broad question, it included instructions to this court that, in my view, are at odds with the question that has been posed. This is problematical because the federal district court it included the assumption that the trigger date for the statute of limitations depends on how the question is framed in the complaint. Specifically, the federal district court assumed that if the plaintiff describes an unconstitutional taking, or also known as an inverse condemnation, then the answer will be different than if the plaintiff describes it as based on an illegal tax. Now, perhaps that's so, I don't think so, but that's a question for this court to answer. That is not something for the federal court to dictate to this court. That's a question of state law. Valley County would respectfully suggest that the federal district court's premise is wrong. It appears to be based on a misreading of Judge McLaughlin's decision in the Her case. I think that's how you pronounce it, H-E-H-R. I don't read Judge McLaughlin's decision that way, nor do I read this court's decisions in Her, Alpine Village, or Buckskin as recognizing that there is any distinction between the causes of action for inverse condemnation and illegal taxes. I would suggest to the contrary that they are bound together. White's cause of action is inverse condemnation. That is, it is a taking of property without compensation. This court has long recognized that there is that cause of action which arises directly out of the Constitution. But inverse condemnation must be based on some legal theory. For example, it could be based on a plaintiff alleging that the county built a road in his backyard. That would be a physical taking. Or the plaintiff might allege a downzoning that resulted in such a complete devaluation of the property that it constituted a per se taking. Alternatively, a plaintiff might argue that a condition was attached on an exaction that was disproportionate to the impact that it was designed to correct or lacked a proper nexus. There would be yet another theory. None of those theories are in play in this litigation. Instead, there's a different theory supporting the inverse condemnation, only one theory, and that theory is that there was an illegal tax in violation of Idaho's taxation clause. That allegation of illegal tax is the sole basis for the inverse condemnation alleged by White. If there's no illegal tax, there's no inverse condemnation. There's no independent basis for the inverse condemnation claim. The whole thing stands or falls on the illegal tax theory. Now, White can draft her complaint with as many counts as she wants, but they all boil down to one thing, that there was an illegal tax imposed. Now, if the federal court was correct, this is where I start to get confused as to what it is the federal court wants this court to do. If the federal court were correct, that the statute of limitations runs differently on White's first count than on her second count, that would create quite a conundrum. The federal court ruled that what it called the inverse condemnation claim, that cause of action did not accrue until the county was presented with a final road development agreement. I think that's incorrect, but that's what it held. And that only when she had the final development agreement, spelling out the exact amount, did her cause of action accrue for inverse condemnation. Accordingly, the federal judge ruled that the inverse condemnation survived. On the other hand, by certifying this question, the court apparently believes that it is possible that the illegal tax claim may have accrued earlier than that. Well,
in the certified question, it talks about an illegal impact fee, but in the discussion in the order, it talks about an illegal tax. And it looked as if the U.S. court was saying they're exactly the same thing. Is that correct, or?
Perhaps, I think that may be what the court was thinking. Of course, the court didn't draft the certified question. I drafted it.
It's your fault.
I guess you could say that, Your Honor. And when Martin Hendrickson and I drafted that question, we had no clue that the court had it in its mind that there was this distinction that it drew only later when it certified that question, and then told this court, well, talk about one thing, but don't talk about the other thing. And so when it talked about this allegedly illegal impact fee, I think the question is broadly framed. It could be allegedly illegal because it's an inverse condemnation, because it's an illegal tax, or maybe that's all the same thing. But it certainly was not intended to be that narrow. And likewise, in all of our briefing to the federal court, we never suggested that there was a difference. And this is something that the federal court came up with without the aid of oral argument, by the way, on its own. And I just don't think it can be reconciled with the holdings of this court. I think we got bollocked up. I mean, what would the outcome be if the court were to find that the inverse condemnation claim survived the statute of limitations, but the illegal tax claim violated the statute of limitations? What's the result? One, the inverse condemnation claim depends on the illegal tax claim for its basis. So how can it survive if the other doesn't? I don't know. I find it impossible to separate the two. I view the illegal tax claim as the basis for the inverse condemnation. There are lots of inverse condemnation theories. Illegal tax is one of them.
Has it been argued in this case that there's any other basis for it?
No, Your Honor. White has never suggested that there is any other basis. I mean, the only other bases are the ones that I mentioned. I mean, in theory, it could be a physical taking. She's not alleged that.
As far as your position is, that it's always been based solely on the illegal tax thing.
That is correct, Your Honor. And I don't think that the White will contradict me on that. I mean, that has been her sole theory throughout this litigation. Now, White has also complained that Valley County is seeking a ruling on the merits, and I do want to be clear on that. Valley County did include a footnote 4, within the statement of the case that speaks to the merits. We're not asking the court to rule on the merits. We wanted the court to have some background information and to understand that we do have an argument on the merits, but we're not seeking a ruling on that. We have also been criticized for talking about the 28-day rule. And in fairness to White, it is true that we had a separate certified question that went to the issue of whether the 28-day rule under LUPA is exclusive or not. And the federal court chose not to certify that question. We briefed the 28-day rule nonetheless. And the reason that we did it is we think that there is an argument that there is an interaction between the 28-day rule and the 4-year rule. And the California case that has been discussed, Ponderosa Homes, specifically found that if there's a more specific limitation period in a land use statute, that becomes, quote, the applicable limitations period, end quote, and overrides the general statute of limitations. I thought that was a reasonable way of looking at it, and if this court were to agree, then that would provide an opportunity, I think, legitimately within the framework of the certified question to opine on what the applicable statute of limitations is.
Well, theoretically, and since this is beyond the scope of what we were asked, but if the 28-day rule were to be invoked, did Ms. White know at the time the CUP was issued that this development agreement that was called for would include a charge for developing roads? Counsel for Ms. White says that they didn't know. what that meant at the time.
Justice Jones, I'm perplexed by counsel's response to your question earlier, because White has already conceded this point. I have here White's brief to this court. This is what White said. White said, after paying the impact fee for phase 1 of White Cloud subdivision, this is page 1 of the brief, the very first paragraph, second sentence. Pursuant to Valley County's implementation of a capital improvement program, CIP, and requirement that White enter into a road development agreement, RDA, White filed this lawsuit seeking a declaration that the payment of the impact fee was an illegal tax, etc. So in other words, this lawsuit was filed pursuant to the county's implementation of a CIP and the requirement of a road development agreement. Both those events were in place in 2005, more than 4 years before the lawsuit was filed. On the date that the
in your brief, though, you indicate that the CIP was not actually implemented at the time that the CUP was issued.
The CIP, as I understand it, Your Honor, is perhaps a multi-layered thing. In other words, there was a broader capital improvement plan that says we are going to do this throughout the county. And then they implemented a particular region-by-region calculation for each geographic area, each traffic zone. And depending on the particular road needs in that traffic zone, the fee might be X number of dollars per residential unit, whereas in the next traffic zone it might be Y dollars per residential unit. In no circumstance would it be $0 per residential unit. And you had asked counsel for White earlier whether White knew that she would have to pay something. I find it implausible that she did not. This was not her first development, and the federal court, in its opinion, acknowledged that she had paid a fee earlier. I don't recollect if it was paid in cash or in kind, but this was not her first road development agreement. So she knew the drill. Everyone in the county knew the drill. This was what the process was. And when the CIP says you shall enter into a road development agreement, there was a CIP in place in June of 2005. And your question, I think, was a thoughtful one when you asked, is there any doubt that the CIP was in place before the statute of limitations period? And the answer is no, there is no doubt. The CIP is just dated, it just has a month on it, so we don't know which day it came out, and it seems to me that the sequence is fairly clear that it was in place before the CUP was issued, but even if it came out a few days later, it was clearly before 4 years. So I don't think there's really any doubt about this. And in any event, the record is also clear that there was this draft road development agreement that was delivered. Now that was the one that the federal court ruled was insufficient still to trigger the statute of limitations. You know, that is, there was no, cause of action had not accrued. And it's perplexing to me. The federal district court wrote, it would be against basic contract principles to say just because one side has provided a draft agreement, there are no further negotiations and the parties are fully aware of all terms, end quote. Now, with all due respect to the federal district court, the statute of limitations accrual date is not based on principles of contract law. There may or may not have been a contract then, but the issue before the court is, was there a sufficient awareness of a substantial interference with property? That is the the standard that this court has consistently applied to inverse condemnation cases. And this court has been very clear in its decisions that there is no precise requirement for quantification of that. I cannot fathom why there would be a justification for adopting a special rule for illegal tax cases. Essentially, that is what White is asking for, that all other inverse condemnation cases are based on when there when it becomes apparent that there will be substantial interference. She says, well, it ought to be different for illegal tax cases. Well, if that rule were to be adopted, I am fearful that we will have great uncertainty in the land use process. It will be a heyday for land use lawyers, but it will be a bad day for everybody else, because we can have cases that involve a down zone, a conditional use permit, a subdivision, an exaction, an illegal tax, all wrapped into one. And then we're going to say, oh, but the accrual date for a cause of action begins on a different time for each of those things that all happen out of the same set of events. That would be very confusing to me, and I find it difficult to imagine why this court would want to go there. There is obviously no Idaho authority suggesting that there ought to be a departure. The only authorities that have been cited by White and described by the federal district court are these out-of-state cases. And the out-of-state cases I don't think are helpful to White. Clearly the Ponderosa Homes case is helpful to Valley County. That case is very close to the situation described here. In that case, there was a traffic mitigation fee that was imposed as a condition of a subdivision. And the developer waited until the third phase of the project to challenge the condition. That sounds very familiar. The California court ruled that the cause of action accrued when the condition was imposed, not when the fee was paid. That is exactly analogous to what we have here. Now, White said in Mr. Villegas' oral argument a moment ago, oh, but that involved a different statute. Well, of course it was a different statute. But the issue is not how long the statute is, whether it's so many days or some other number of days. The issue is, what is the trigger for the date of accrual? And that principle, it seems to me, is analogous to what we have here. That is, frankly, the only one of the 10 cases that are discussed that is directly analogous to the White case. Now, the other case that is nevertheless helpful to the county, but a little bit different, is the Frederick case. The Frederick case is different because it wasn't an exaction case. Rather, it was a drainage tax that was imposed across the board on all property owners. But nevertheless, the court found that the accrual date was earlier than the date of payment. Now, there are 8 cases that are relied on by White, these 8 out-of-state cases. Not a single one of them is analogous or on point. Now, 6 of those cases involved a situation where the statute of limitations had already run based on the time of payment of the fee. Hence, there was no reason to look back any earlier than that. For example, in 4 of them, the argument was that the statute of limitations should occur or should start later at the time that the statute involved was declared unconstitutional. And, of course, the court rejected that 4 times, just as this court has rejected that in the McCuskey case and the BHA2 case. But that has nothing to do with the situation that we have here. Now, moreover, it bears emphasis that none of the cases relied on by White explored whether a cause of action would accrue at the time that the impact fee was imposed as a condition of development. Not a single one of White's cases involved that. They involved all sorts of other things. The Kuhn case was an income tax. The Watts marketing case involved personal property taxes. Lowenberg was a fire registration fee. Howard Jarvis was a utility tax. I could go on. But in each of these, the point is there was nothing earlier to look to. So it's hardly surprising that the court in those various cases would look at the date that the fee was paid. Here, however, we have a situation where there was the imposition in the conditional use permit of a clear mandate that there be a development agreement. That development agreement was based on a CIP, which is in the record as having been in place in the same month as the CUP. It may be that the actual quantification did not take place at that time. It took some while, but the regulatory mechanism was crystal clear on the day the conditional use permit was handed down, and it was certainly crystal clear on the day that the draft road development agreement was presented to the plaintiff. Your Honor, I think this case is a simple one. I think that this court need do nothing other than look to well-established principles that have been established in other inverse condemnation cases and say this one is no different. In doing so, I urge the court to address the conclusions reached by the federal court on this issue of whether there's a different calculation based on whether it's an inverse condemnation claim or an illegal tax claim. But at the end of the day, I don't perceive this as a difficult case, and it's one that it seems to me there's an opportunity to establish a clear set of guidance so that counties and other litigants don't have to spend the enormous amount of money that has been chewed up in this litigation to date. I'll stand for any questions, otherwise I've concluded my oral argument.
Nothing. Thank you, Your Honor. How much time does the appellant have? Sir?
Thank you. I'd like to address counsel's arguments. And as I was sitting there taking notes, I wrote here slippery slope because my response brief to the respondent's brief was a lot of the issues that were raised in that briefing were outside the certified question. But to the extent that it touches upon maybe a different test for accrual, I would like to address that, Your Honors. And that is the county's position that this court should adopt the test for accrual to the inverse condemnation cases, the TIB standard, when a party is made aware, or actually let me just read it to you, is to be fixed at a point in time at which the impairment is such a degree in kind as to constitute a substantial interference with plaintiff's property or interest became apparent. Now, I did address that in our reply brief, and that is that that's the wrong test. This test was developed by this court because there were many examples in which harm could not be sufficiently established when the damage was sufficiently established. Or specifically, this court has held it's not susceptible to exact determination. We submit in this case it's really simple to figure out when someone's money was taken. They don't have it anymore. That's the whole basis of the refund claim. Ms. White is asking for a refund on the basis that the money that was collected was illegal. Now, again, as I started, I said slippery slope. I do want to address at least this issue to the extent the court finds it germane to its decision that an inverse condemnation claim and this refund for an illegal tax is the same. It's not. This court has held that the taking of one's property is not what's unconstitutional in the context of an inverse condemnation claim. It's the failure to pay just compensation. In this refund claim, we are arguing to Judge Lodge that this is an illegal impact fee. We have a different burden. We have to prove illegality. And to that extent, I don't want to go beyond that because there are certainly many issues still left for trial. I do want to clarify the record, though, that counsel had suggested that neither party ever looked at inverse condemnation and illegal tax as a separate thing. Well, I will submit to this court that that is incorrect. In the clerk's record, particularly in the parties' briefings on our motions for reconsideration from Magistrate Judge Dale's report and recommendation, I wrote the brief. I know it's there. I specifically wrote and said that there's actually two different causes of action here. The levels of proof are different. That pronouncement of law that I just quoted to this court regarding the inverse condemnation and it being unconstitutional only upon the failure to pay just compensation, that's all in that briefing there. And I apologize, I don't have the clerk's record. It was voluminous, and so I couldn't bring it with me. But it is there in the cross motions. In the motions for reconsideration. I know it's there. To address counsel's statements that it was clear that Ms. White knew, Justice Jones, your question, it was clear that Ms. White knew that a fee would be imposed. Again, slippery slope. I know I've asked this court, please don't consider that. It's not germane to answering the certified question, but I feel remiss not to at least address that. You'll find that yet again where the county tried very hard to try to impute knowledge through one of the Ms. White's engineers. I mean, that's still an issue of fact to be resolved at trial. And at that, so it's not true, Justice Jones, that she knew anything.
I think, as I recall in Buckskin, it was the receipt by the engineer who was representing Buckskin that provided the tip-off that this money was going to have to be paid.
Yes, Justice Jones. Because I'm in a unique position with us being counsel here, he was also the authorized representative, Your Honor. Mr. Finley was the authorized representative, which is why there was all of the briefing regarding that matter of when Ms. White knew. And so it's not directly analogous to the Buckskin case.
It's not entirely a facetious question. I understand the bright line rule that you would like us to adopt, and I guess I'm going to look for some clarification on is exactly when the cause of action for an illegal tax would accrue. Is it at the time the check is delivered, postmarked, honored by the bank? Do you see what I'm asking?
Yes, and Justice Horton, our position is when the party is separated from their money.
Is that when their bank, the draftee bank, honors the check?
Yes. When that funds leave that particular account, it may not be a bank. A fee payer can come in and pay by cash. When it leaves their possession and it's no longer theirs, and
But typically, 180-odd thousand is not going to go out in ones.
Well, unless it's a cashier's check, so I mean that would be another thing too. So, with that, Your Honors, I have nothing else to add. I stand for any additional questions.
None. Thanks again.
Thank you.
This matter is under advisement. We'll render a decision.